Welcome all to our Emerging Issues webinar. Our presentation is entitled PFAS, the tip of the Tort Iceberg, and we're thrilled to see so many of you on the call with us today. I'm your host, Andy Blanchard, and I lead our Emerging Issues team here at Verisk. With that, allow me to start with our policy statement that you see on the screen here. The policy of Verisk Analytics and subsidiary companies is to comply in all respects with federal and state antitrust laws. With this in mind, we want to mention that during all seminars held under our auspices, this policy prohibits discussion of certain topics. Because we want to avoid even the appearance of an antitrust violation, we go beyond the letter of the law, and we will not discuss any matter that violates the spirit of the antitrust laws or could be perceived as doing so. A copy of our policy statement on discussion at meetings can be found at verisk.com/statement. And with that, I would like to introduce our Verisk attorney, Jason Kurtz. Jason, would you like to offer us a few words of guidance before we get going here?
Sure, thanks, Andy. Good morning, everyone. It's at this point that legal likes to just add a quick and gentle reminder with regard to our policy statement at meetings to please be reminded to refrain from sharing any details regarding policies or intentions of any company in the property and casualty industry, including that of your own company. If we could just avoid any specifics in that regard and just share any general opinions and observations, that would be greatly appreciated. I'll be monitoring the meeting in case we may in case we may go off track at any point, and I'll steer us back on course, and otherwise I will be listening in as well. That's all I have.
Thanks, Jason. Hopefully we won't need to be redirected, but happy to have you here just in case. As soon as we jump in here, before I wanted to kind of move ahead, I just wanted to call out a few things quickly. Use the chat function to go to webinar. We'd love to hear your feedback and your questions. It's good for us, it's good for those listening to hear that if you have a question, good chance someone else out there has that same question. We will endeavor to answer all questions, but sometimes we run out of time. Have no worries, we will follow up with you afterwards to address your question if we can't do it during today's live event. Also, and because we get this question all the time, we are recording the presentation and intend to post it on our website at core.verisk.com shortly thereafter. So just keep an eye on the website and you will see this recording up there soon. That is the goal. So before we really jump into the meat of this, our dedicated emerging issues team here at Verisk, we track over 70 emerging issues, but there are myriad reasons why we felt compelled today to bring this particular topic to you, this topic of PFAS. And to give this topic the proper treatment, we've assembled three really deeply, I should say, insightful and skilled presenters, starting with a voice you've heard a lot, Greg Scobletti, an analyst on our emerging issues team. He'll be handing it off to Lucian McMahon, who is a senior manager at Arium Liability Analytics with Verisk. And fun fact, Lucian cut his teeth at Verisk as an analyst on our emerging issues team. So friend of the family, we're psyched to have him here. And finally, we're thrilled to have Bill Wilt, president of Assured Research, on the call with us. We've collaborated with Bill a lot before. It's invariably a rewarding and fruitful endeavor when we do. And I can tell you personally, I learn something new every time I speak with Bill. I read his newsletters, I follow him on LinkedIn, so really happy and psyched to have Bill with us. And with that, I'm going to pass the mic to Greg.
Wonderful. All right. Thank you, Andy, and thanks everyone for attending. So I'm going to get things started with a brief overview of some of the recent regulatory activity on the PFAS front, followed by some of the latest health research we've seen, and then close that out with a look at some of the remediation challenges that lie ahead of us. So, likely not news to many folks who follow the PFAS issue, but in April of this year, the Environmental Protection Agency finalized their long-awaited National Primary Drinking Water Regulation. It sets legally enforceable levels for the PFAS compounds you see here for the nation's drinking water utilities. The EPA estimates that around 4,000 to 6,000 water systems in the US will have to take action to remediate their systems based on these new standards. And the clock is ticking. Utilities have until 2027 to complete their initial monitoring, and if they detect PFAS that exceed these levels, they will need to remediate their systems by 2029. Now, one of the central questions around this regulation, and I think likely to be a theme of this webinar, is how much this will cost to implement. The EPA estimates around $1.5 billion a year for water utilities to tackle PFAS contamination, but there are private estimates that suggested it could be significantly higher, maybe as much as double that figure at around $3 billion a year. And perhaps not surprisingly, we've also seen several legal challenges to the regulation, and one from the American Water Works Association and the Association of Metropolitan Water Agencies. These collectively represent a lot of the utilities that will be responsible for remediating the water supply. Their lawsuit claims that the EPA had, quote, significantly underestimated the cost of this regulation. And while the drinking water is obviously one of the more key items on the regulatory front, it is really far from the only action. So in tandem with the National Drinking Water Regulation, in April, the EPA also designated two PFAS compounds, PFOA and PFOS, as hazardous substances under the Comprehensive Environmental Response, Compensation, and Liability Act, which is also known as the Superfund Law. And they released a statement about how they plan to enforce this, given how widespread PFOA and PFOS contamination may be, and the number of parties that may have contributed to its spread. And I'm not going to quote it for you here, but you can see they're looking for parties that may have played a significant role in exacerbating the spread or release of PFAS, or those who may have manufactured PFAS or used PFAS in the manufacturing process. So that could still be a sizable cohort of organizations, but time will tell. And the science on PFAS's potential health risk also continues to evolve, and I think we can safely say that it's grown more concerning over time and not less. Now, I'm not going to dive into all of this here today. I just wanted to highlight several items that might be significant. First, we're learning about new ways that individuals can be exposed to PFAS. So obviously, there's a lot of focus on drinking water at the moment, but a new study from the University of Birmingham revealed that multiple PFAS compounds can be absorbed through the skin and enter a person's bloodstream. So what's important here is that, at least according to the Birmingham researchers, the prevailing wisdom was that PFAS couldn't be absorbed through the skin. Now, we had studies prior to this that showed a correlation between the use of personal care products and PFAS concentrations in blood and breast milk, but this new research suggests that PFAS can actually cross the skin barrier. And what's more, multiple types of PFAS appear capable of doing this. So the researchers examined 17 of the most widely used PFAS compounds, and they found that 15 of them had, quote, substantial skin absorption. So this suggests that personal care products may be a more potent source of exposure to PFAS than previously understood. And there was another interesting finding in this study. They found that PFAS with a shorter chain of fluorine atoms were more likely to be absorbed by the skin than PFAS with a longer chain of fluorine atoms. So why does this matter? Why the chemistry lesson? Well, it was thought, particularly years ago, that some of the more concerning health impacts and environmental impacts from PFAS were the result of those longer chain PFAS compounds. Think of things like PFOS and PFOA, which I spoke about a bit earlier. Companies had reportedly been transitioning to these shorter chain compounds in the hopes that they wouldn't have the health baggage and the environmental baggage of those longer chain PFAS compounds. But this and other research suggests that that shift, that substitution, is not alleviating the risk, and at least in the case of skin absorption, it may actually be exacerbating it. And it's not just skin absorption. So research published this year in the journal Chemosphere found that individuals who wore contact lenses had higher concentrations of PFAS in their blood than those who didn't wear contact lenses. They also found concentrations of PFOA at levels where, quote, adverse health effects could be expected. And speaking of adverse health effects, we are learning about more of them that may be potentially linked to PFAS exposure. For example, there was a study in Italy that monitored a population that was exposed to a significant release of PFAS over the course of several decades. Now, these individuals had higher incidence of cancers, but those cancers had been previously associated with PFAS, such as kidney and testicular cancer specifically. But the individuals were also found to have a higher incidence of cardiovascular disease, which is a relatively novel finding linked to PFAS exposure. And another study published this year found possible linkages to PFAS exposure and brain and esophageal cancers as well, another novel finding. So like I said, the more we are learning, the more troubling it appears. So we'll turn to PFAS remediation now, and this is really a multi-dimensional challenge. At a high level, those same chemical bonds that make PFAS such a useful industrial chemical make it very difficult to destroy. So there are techniques today that are capable of capturing and filtering PFAS out of water. That is the absorb and separate portion of the slide verbiage here. But that destroy piece still seems to be something of a conundrum. So the EPA has released interim guidance on PFAS disposal, but as you can see on this slide, almost every option available to us has some potential issues. It can be tough to dig PFAS out of the ground because these compounds have a tendency to sink very deeply into the soil. Purpose-built injection wells that can hold PFAS compounds more securely are reportedly in very short supply. The combustors that we use to burn hazardous waste may not be suitable for tackling PFAS, and the incinerators that we use for your everyday municipal waste appear to have the potential not only to not destroy PFAS, but also to just re-release it right back out into the air. So all these challenges add up to what might be a very complex and potentially very costly effort to address PFAS contamination. And as you can see from this Bloomberg item we've highlighted here, the costs appear to be outrunning both possibly the settlement money to date and the federal and state dollars that have been dedicated to this effort so far. So now I'm going to turn things over to my colleague Lucian from our Arium Liability Analytics team, who's going to discuss some of the modeling that he and his team have done on PFAS risk. Lucian?
Thanks, Greg. Hello, everyone. As Greg mentioned, my name is Lucian, and I work in the Arium Liability Analytics group here at Verisk. For those of you who don't know us, Arium is a liability catastrophe modeling platform that generates analytics for carriers and brokers to help manage systemic liability accumulations on their portfolios, including for events like PFAS. And so in my portion of today's webinar, I'll be providing some perspectives on how we in Arium approach modeling the PFAS event. So in Arium, we've developed a model that estimates the potential insurable ground-up losses in the United States arising out of PFAS contaminated drinking water and related environmental litigation. So from our perspective, we believe that the contaminated drinking water and environmental pathway is and will continue to be the greatest concern for PFAS from a large loss litigation standpoint, at least in the near to medium term, though of course this could change as research and regulatory activities develop, as Greg touched on in his portion. So as we all know, PFAS can enter soil and drinking water sources from many, many different industrial and business operations. Many people are at risk of PFAS exposure from their drinking water sources, and it's the current scientific understanding that it's really through this pathway that people are most exposed to high amounts of PFAS that could then subsequently generate concerns about potential health impacts. And as Greg alluded to, it's really the exposures to PFAS in drinking water and other environmental pathways that have garnered the most legal and regulatory attention to date, especially in the United States. And so just to give you a flavor of the type of event we could end up seeing, which I'll be discussing in subsequent slides, our most severe model estimate pegs the total potential ground-up loss at $165 billion, which is again the ground-up loss, meaning before the application of liability insurance terms and conditions, which is a very important distinction to make, and I'll discuss that in a bit more detail later on. But of course, PFAS is a highly complex, dynamic, and uncertain issue for our industry across multiple different dimensions. So the question we have to ask is, how can we even begin to build a useful model to estimate potential losses given these complexities? So I like to think about this question as essentially an exercise in breaking down a very complicated problem into much smaller and much more manageable pieces. So first, we really have to start at the most basic level, right? How might a risk like PFAS translate into a large loss liability event that may ultimately impact carriers? So in other words, given our current information, data, and the available expert opinion, we need to construct a plausible and reasonable narrative for how litigation might develop and ultimately spread across companies. And because we can't ever pretend to predict a highly uncertain future with anything approaching 100% confidence, I would argue that there's really no getting around this initial step of narrative building, again, using the best available information so that we can calibrate a credible model. So in the PFAS context, it's of course the drinking water and environmental contamination pathway that may continue to develop into an ever-growing litigation event. And that narrative is the starting point from which all other model components and parameters will flow in this presentation. So taking that narrative, we can then apply research and data to construct a possible event footprint, right? Which industries could be exposed to PFAS litigation going forward? Now, for highly uncertain events like PFAS, we may want to take a fairly expansive view of that event footprint. So for example, we might have pretty high confidence that some industries are highly exposed to the event. We of course know that certain PFAS manufacturers have exposure simply by virtue of them already having been sued and already having paid out some losses in the form of settlements. But we might have greater uncertainty for other industries that have not yet faced any claims, but which plausibly could, based on where they sit in the PFAS supply and distribution chain. And so given these uncertainties, we would therefore want to include those industries as well to develop the fullest possible view of the event footprint, since we're ultimately trying to capture the full possible scope and scale of the event in a model. Similar thinking applies to the companies or organizations within those industries that might have exposure to this event. We, of course, can't necessarily always identify exactly which companies could be brought into litigation. That's ultimately the benefit of taking a modeling approach here, where we can simulate various potential outcomes to reflect our uncertainty around these parameters. So think about PFAS in this context, right? With the current available data, we can't necessarily say exactly which companies or which facilities, which locations might be releasing PFAS into the environment, and to what extent and over what period of time across the entire United States, right? That type of data granularity is currently quite hard to come by, or it's inconsistent, or it's incomplete. But we can make some straightforward assumptions here to at least get a reasonable view of the types of companies with likely exposure. So for example, companies that are within an industry known to touch PFAS and which have a sizable manufacturing or facilities footprint in the United States. Right? These companies could potentially be assumed to have some exposure to litigation that could then be picked up in a model simulation. So at this point, we can tie our litigation pathway, our narrative, and our exposures, right, our industry footprint, to then contemplate how damages and potential ground-up losses could arise through litigation. So we have to first ask ourselves, who are the possible classes or groups of third parties that might plausibly allege to have been harmed by the activities of these companies in our footprint? And based on research, data, expert opinion, historical litigation, and other parameters, we can then make informed assumptions around what possible future litigation might look like. And again, in this PFAS model, we're really focused on that environmental and drinking water issue. So our damaged parties could be, for example, public and private drinking water sources, including utilities, who might seek to hold companies responsible for the cleanup and remediation of PFAS contamination that is found in those drinking water sources. We might also want to consider the populations exposed to PFAS in their drinking water who might generally allege, for example, some type of bodily injury or property damage. Once we have our damages, we can then simulate how those damages might be allocated across our exposed industries and companies that then translate into ground-up losses. That is to say, the possible payouts, settlements, compensation, awards, and so on that might flow from defendants to plaintiffs before the application of any liability policy T&Cs. Now, before I go into more detail about some of these components specifically in our PFAS model, I'd like to just reiterate that this type of framework is really designed to rationalize a complex problem. The complexities and uncertainties related to PFAS do, we believe, require us to take a somewhat aggregated view of the event. We're not currently modeling at a very granular individual PFAS claims level, but are rather simulating at a more aggregated industry level how liability might emerge and translate into ground-up losses that then could flow into a liability portfolio under certain assumptions. And of course, any emerging risk model outside of PFAS, beyond PFAS, needs to be flexible enough to incorporate new information and new data that may, for example, trigger changes to our forecast of losses, or may even trigger changes to the fundamental narrative of the event as litigation evolves over time. So now let's dig into the industry footprint for our PFAS model, given our narrative and our framework. So we've broken out the various exposed industries across three main sectors, as we call them. And if you've been following PFAS developments, this breakout will look somewhat familiar to you, I'm sure. So first, we have the primary manufacturers, right? These are the industries known to manufacture PFAS chemicals. And we generally assume that these industries will continue to face a significant amount of litigation and potentially large losses. We also assume that liability will flow to what we term the secondary manufacturers. So these are industries that are known to use or incorporate PFAS into their products and components. And this can include everything from textile manufacturers to electronic manufacturers, to furniture manufacturers, and so on, who all might be releasing PFAS into the surrounding environment that then migrates into drinking water sources. And several companies within some of these industries have already faced some litigation to date, and we assume in our model that that trend will continue going forward and will continue to spread to other industries in this sector. Lastly, we also want to capture the potential exposure for what we generally refer to as the non-manufacturing industries. These would include, for example, wholesalers of PFAS chemicals or products, such as wholesalers of AFFF firefighting foam, which in some cases have already been named as defendants in some cases. The sector would also include landfill management and waste remediation companies, and it would also include entities such as airports and energy refineries due to their heavy use of AFFF firefighting foam that can then migrate into drinking water sources in the surrounding area due to their use of those products. And so here too, we've already begun to see some developments in this area. Now, this sector level view of the footprint does mask just a little bit how systemic this event footprint could ultimately be. So our research and data indicate that dozens of industries within these sectors and potentially hundreds of companies within those industries have some potential exposure to PFAS litigation in the United States, again, depending on how this event ultimately unfolds going forward. And as I alluded to earlier, we believe that this expansive view of the possible event is really important to capture. So that way we can leverage a model to quantify exposures in portfolios across different classes of business. So now to the exciting part. Given our narrative and footprint, we can now consider how PFAS-related losses might actually accumulate across those companies and industries in our model. So at a very, very high level, our model essentially takes 3 steps to estimate our losses. So first, we simulate the number and size of contaminated drinking water sources. There are already thousands of known contaminated water sources in the United States, but it's still very early days. So our model assumes that thousands more will be found to be contaminated as testing increases and spreads, due in part to some of the EPA activity that Greg mentioned earlier. Based on this simulation, we can then estimate the populations who might be exposed to PFAS from these contaminated drinking water sources and may thereby be at risk of potentially contracting certain types of cancers associated with that PFAS exposure. It's at this point that we add further nuance to our model by also segmenting the exposed populations based on a few different parameters, including estimates for what their levels of PFAS exposure might actually be. So we think that is a very critical point here, because if you just take the raw numbers of people who might have some exposure to PFAS in their drinking water, you will very quickly find that a very sizable portion of the entire US population is exposed in some way, tens, if not hundreds of millions of people. But we don't want to assume that all people who have some exposure will be realistically able to claim damages, given the ubiquity of that exposure and the uncertainty around how some of these lawsuits will move forward, especially given that there is not yet a signature disease tied to that PFAS exposure. So here we assume at a high level that generally those populations that might have significant exposure to PFAS may have a correspondingly greater expectation of receiving compensation for various potential bodily injuries. So based on these two initial outputs from a simulation, right, we have our contaminated drinking water sources and we have the populations with some exposure to that contamination. We can then estimate the potential losses that might flow within litigation through to those companies and industries in our footprint. And so from a ground up loss perspective, our model assumes that this event will be predominantly concentrated on cleanup and remediation costs, a bodily injury and property damage type payouts, and we also included some possibility of some medical monitoring claims as well, despite some of the difficulties on that front, to provide the most complete view of the event as possible. And as I mentioned at the outset, our current model's most severe simulated loss estimate pegs the total ground up loss at approximately 165 billion, with of course a range in that number given the uncertainties. So we have a mean loss of just about over 130 billion dollars. Now, I've been using the word uncertainty quite a bit in this presentation, and unsurprisingly, there are quite a few uncertainties around how the PFAS event will continue to develop. So for example, the costs of PFAS cleanup and remediation are highly uncertain, as Greg touched on earlier, especially as the acceptable levels of PFAS in drinking water continue to be lowered. Nonetheless, these costs tend to comprise a significant portion of our total event loss estimates, and we believe that that's reasonable based on the way trends have been developing. Another key uncertainty in the model is that personal or bodily injury component from this event. So we are aware of some settlements in the past for health-related impacts from PFAS exposure through drinking water, but we're still very much in the early days for how these types of lawsuits may ultimately make their way through the courts and what those payouts might ultimately look like. And we saw some of those developments already earlier this year in some of the litigation and settlements coming through where the personal injury discussions were not yet addressed. And so while there is evidence of association between PFAS exposure and certain types of health impacts, again, there's not yet that definite link or signature disease, and so thereby that increases the uncertainty in estimating these types of losses and really drives some of the variability in our estimates. However, by perturbing some of the key assumptions and variables in the model, we can simulate thousands of different potential loss outcomes that capture some of that uncertainty. And then we can then generate a credible range of loss estimates and how those losses ultimately spread across our industry footprint. Now, before I pass it to Bill, I would just like to end with a few thoughts. And the first is that I've been using the terms ground up losses or economic losses throughout this presentation. Again, when I use those terms, what I mean is those loss estimates before the application of liability terms and conditions. There is significant uncertainty around the question of insurance impacts related to PFAS. Many different lines may have potential exposure depending on the way the event unfolds, perhaps even in lines that we might not immediately think about. For example, if there were to be some kind of event-driven D&O type event like we've seen in the past from other large litigation events. And so given these uncertainties, we've purposefully calibrated the model on this ground up basis, because in that way, while we're not commenting on the ultimate insurance impacts, in this way, carriers and brokers can nonetheless develop their own view of risk for this event, and they can then stress different assumptions for how their portfolios might or might not respond to these losses and take a more expanded view of the event potentially as well for, say, defense costs and how different accident years might be exposed over time, since that $165 billion loss estimate is the total loss estimate. And of course, there's the question of how those losses will be allocated across accident years. And to provide a view of the ground up basis allows carriers and brokers to develop their own view of risk for those various uncertainties. And so with that, I'll pause there and I'll pass it over to Bill. Thank you very much.
Great, Lucian. Thank you. Much appreciated. Very thorough and informative indeed. Listen, thank you to Andy, to Greg, and really the whole Verisk team for all the work that you're doing first, but also thank you too for inviting me to join in this discussion. An important one indeed. And I'll share with you our thoughts, and probably important to draw a line between the presentation thus far and our work. I think my role here and what I find myself doing with PFAS is trying to peer into the future and think about how this might unfold. So clearly anything that I share, the views of myself and Assured Research, and of course also highly uncertain. But when thinking about PFAS, I found myself thinking about, again, the path forward and an important event in the not too distant future now, and that is the upcoming election, the presidential election, which could may or may not result in a change of administrations, but elections, to use the trite phrase, have consequences, and it really is true, I think, in the case of PFAS. So that's kind of the overarching theme here. But to be clear, and again, our views, those of Assured Research, do think, and I'm looking at the top of this slide, that the financial pressures from mass torts generally, and certainly from PFAS, they're going to continue. The plaintiff's bar is really, at this point, functioning like a well-oiled machine. There are already plenty of suits and and settlements underway. Those will continue, and the private actions, I believe, will continue in the near term, the medium term, and perhaps the longer term as well. But what I want to focus on here is our assertion that the intensity of that near-term pressure really could be influenced by the upcoming presidential election. And what we'll do is look back into the 1990s. Some of you, perhaps many of you on the call, were working in professionals at the time, but even if you weren't, you've probably you're broadly familiar with the developments regarding asbestos and environmental losses. And in particular, they really became supercharged. We're going to focus on environmental claims. Really became supercharged in the early to mid 1990s. We'll look at why and kind of perhaps draw parallels between then and now, depending on how the election goes. So here are the topics. Are we going back to the 90s and the others that you see there? Let's jump right into it. Are we going back to the 1990s? So I think the EPA was formed in or around 1970, enabling legislation. RCRA, RCRA, and Greg and Lucian both, I think, already referred to this, the CERCLA law in 1980s, otherwise known as the Superfund Act. So the enabling legislation that the EPA really relies on and to carry out their statutory duties to focus on the environment and clean up the environment, they were in place. And we'll see in I think the next slide that something like 60% of today's, cumulatively from 1970 or thereabouts to 2023, let's say year-end 2023 or early 2024 when I got the data, something like 60% of those Superfund sites that are on the list presently, they were identified by 1990. So they were identified by 1990, but there hadn't been a lot of action on them. And then we get into the early 1990s. There's an election and a new administration, and I've shared here the words from the language from the Democratic National Platform, and you see here really strong language. I took out some. There's plenty of very strong language in that platform. We're going to insist that private polluters clean up their toxic and hazardous waste. We're going to vigorously prosecute environmental criminals. Most people who, most insurance professionals, I would submit, who were active, working and engaged in the 1990s, will remember the name Carol Browner. She was the very energetic director of the EPA. I've included here a quote from the Washington Post. Hopefully taken by her as a compliment. I'm sure it was, you know, it was all accurate. It was very active. What else happened in the 1990s? And I got a list in a subsequent slide. The SEC got involved with new disclosures surrounding environmental liabilities. Other actors, other agencies, perhaps I should say, with rating agencies and actuaries were involved. But let's look. Okay, there we go. Let's look at some numbers on the left-hand side here. As I mentioned, something that's the blue bar, or the blue colored area, describes the EPA sites designated put on the national priority list, and something like 60% of those were identified and had been added by 1990, but not a lot had happened. So let's reflect back on what I was just describing and look at both the budget for the EPA, the budget, or the bars there, that's in 2023 dollars, and the size of the EPA workforce. Well, it really, it grew dramatically from the start of the EPA. It grew throughout the 1980s, but the budget was what really meaningfully expanded, and it was a catalyst for the EPA to start really doing its work. You had, again, this governmental agency that was led by somebody who really wanted to make, have an impact. They had the platform and the political support to do it. They had the budget to do it, and that resulted in perhaps I don't have the slide, but it resulted in a meaningful amount of oh good, thank you, there we go. It resulted in a meaningful amount of environmental reserve charges in the mid 1990s. That's the red line there, asbestos and environmental. So you had this confluence of factors, and they really resulted in a meaningful amount of corporations being identified as potentially responsible parties, needing and under the Superfund law, being required to pay to clean up chemicals and sites that they were deemed to have polluted, insurance coverage action, insurance payouts, settlements, so on and so forth. So governmental action really can make an impact. And I'll just point out that, by the early 2000s, kind of the baton passed back from environmental back to asbestos. Those are mostly a result of private actions. Let me just go back here. I think I had skipped one. I'll just point out that in the 1990s, it wasn't just governmental action that was the catalyst for all of this. You had other major actors involved. You had the SEC, which, as I say here, in 1993, passed Staff Accounting Bulletin 92, required corporations to bring environmental liabilities or all contingent liabilities onto the face of their balance sheet. Rating agencies were really active at the time. They were posting their own estimates for the liability ranges. They were incorporating them in their ratings and saying as much. We think, XYZ company could have responsibilities for X amount of liabilities, and that's baked into our rating. The NAIC, it was in the early to mid-ish 90s, I'll say, when they required the A&E footnote, with which many people are now familiar. Now it's standard, but it wasn't at the time. And there was an explosion in the 1990s. So I think from 93 or thereabouts to say the decade later, 2003, more than 20 and I think perhaps even up to 30 or more actuarial papers on how to quantify asbestos and environmental liabilities. So you had this real confluence that came together and led to companies taking reserve charges, or corporations having liabilities, disputes, and so on, settlements with their insurers, and environmental charges. So let's Let's talk about what's happening now. And I just want to make sure I didn't skip a slide. No, I did not. There we go. So in today's mass torts, what's happening? Well, over the course of the spring, when we started doing some research on this and thinking more about it, peering ahead, kind of got on the phone and and sought out folks at rating agencies, the NAIC, some of the other actors that you see there. And it feels like we're still in the early a lot of the major players are still in the early innings of taking a stance. I think it's a matter of public record. All the rating agencies have expressed concern about PFAS liabilities. I know, and again, matter of public record, it's out there that PFAS liabilities have caused rating actions for some of the manufacturers of PFAS. Not aware of specific contemplation of potential future reserving actions that are baked into insurance ratings today. In fact, I don't suspect, based on what I've heard, that there are not any. So that's not a direct parallel to the 90s when those were there, but it's on the minds, I would submit, of the rating agencies. NAIC had a dialogue with an individual there. There's no current, I looked through various meeting agendas and minutes from working groups. They're focused on some of the other issues that you see there, not yet on mass torts, but again, something that's on the minds of regulators, certainly. And you just heard Lucian's and Ariam's thoughtful work on trying to quantify liabilities surrounding PFAS. There's one that I'm aware of, one substantive paper, actuarial paper, on the topic of trying to quantify PFAS. So more might transpire there. We will see. And there's various suits that are ongoing and coverage actions and so forth. They listed a number of mass torts there, not just PFAS, but we keep one toe in the world of in the investing world, and I think it's fair to say that investors are watching this issue and certainly concerned about kind of headline risk. So there's pushback, one could say, on this idea that if, be specific, if the current administration continues for another 4 years, that these recent EPA changes, I think they were both in April, the Safe Drinking Water Act and the designation by EPA of 2 PFAS compounds as hazardous substances under the Superfund law. The supposition, or what I'm offering, is in one scenario is if the administration stays in place, they've got 4 years to really pursue those and go down a path. I'm not suggesting it would look just like it did in the mid 1990s, but the idea is that they might have the channels available to them and perhaps the resources available to them to pursue remediation of PFAS sites in drinking water and so forth. There's pushback. One is there was a case, SCOTUS, Supreme Court of the United States, a case, West Virginia versus the EPA, ruled in favor of West Virginia, which kind of imposed limits on the EPA's ability to regulate greenhouse gas emissions. It's been put to me at different times, hey, doesn't that mean that that would carry over to the EPA's ability, likewise perhaps limiting their ability to regulate PFAS? I thought the answer was no. I talked with a very experienced environmental attorney. got it very clear. The answer is no. The EPA, has the statutory authority to regulate hazardous substances. It's what they do. It's what they've been doing for over 50 years now, and really not relevant. We don't think. There is this issue of the major questions doctrine, and kind of broadly speaking, the rulings that came out of the Supreme Court this year kind of show a shift back toward the private sector, and kind of allow for perhaps greater balance between the private sector and the government. One might argue that, and this major questions doctrine just says that Congress, or it says that courts, the courts will presume that Congress doesn't delegate to executive agencies issues of major political or economic significance. So what might that mean? That could mean, and this is a layperson's interpretation of that the bigger PFAS liabilities become, the more this major questions doctrine becomes relevant. If these PFAS liabilities, the cleanup and the bodily injury and harm to people, the larger it becomes, the more this becomes it could become a really dominant and significant political or economic matter. And in that case, under this major questions doctrine, which is accepted by the Supreme Court, the regulation of that could move back to Congress and kind of away from the EPA. And last, let me mention this, which is, here I'm probably on slightly firmer ground, in that the Supreme Court ended what had been the Chevron, the doctrine of Chevron deference. So that Chevron, I'll just refer to it that way, had referred to the latitude given by courts to federal agencies in instances where the interpretation or enforcement of laws was ambiguous. In those cases, if a private party challenged, let's say the EPA, under the Chevron principle of Chevron deference, the courts would have said, hey, look, it's not for us to get involved here. People at the EPA are the experts. We're going to defer to their interpretation of how to interpret and enforce these laws. I'll give you, and so that's ended, and now courts are able to insert themselves and hear different parties' views. A very practical, tangible example here. One, it has been, you can find, quick Google search, you could find articles, raising the question of whether the EPA has set the drinking water standards so low, with 4 parts per trillion, I believe, that standard is so low as to be scientifically, I'm going to use my word, not the ones that you might find in more thoughtful articles, scientifically irrelevant or perhaps even unmeasurable. Again, I'm embellishing there to make the point. So previously, under the Chevron principle of Chevron deference, there might not have been a pathway for a private party to challenge the EPA, on that matter. Now that Chevron deference has ended, the courts have the option of weighing in and offering their view after hearing experts. So our view is that's a positive in the near term for the industry. I think it lessens the likelihood that irrespective of the administration going forward, it lessens the likelihood that that the EPA could be quite as forceful as it was, let's say, in the mid 1990s. Longer term, you ask the question of whether private legal actions fill any void left by inadequate regulation. That's kind of a philosophical matter. But I'll end and hand it back to Andy just with this observation. You see here on the right-hand side that the EPA's budget, the workforce is lower than it was in the mid-90s. The budget is noticeably lower, and I would submit that the years 25 to 28 could look quite different based on the outcome of the election. I think these Supreme Court decisions have maybe leveled the playing field a little bit, but irrespective, I think elections have consequences. So we certainly will be watching for lots of reasons, but this one included, to see what happens in the fall and then into 2025. So thanks so much, Andy. Let me turn it back to you, and I'll give you control of the mouse.
Thank you, Bill. Great insights from you and the rest. We are moving towards our Q&A portion of the webinar. And as we do, I'm going to remind everyone, if you do have questions, as you pose your questions, I need all help I can get. So if you could please say, this question's for Greg or Lucian or Bill, then I'd be able to direct it to the right person. Before we get there, you can continue the journey here on PFAS. We have a lot of content on our website, our publicly accessible website at core.veris.com. No logins, no passwords, just immediate access. You could jump right into our foundational content on PFAS. We do this for a lot of topics as well. We have current news feeds curated by our EI team. We have originally authored articles. You could sign up for our newsletter. If you've been living under a rock, you haven't heard about it, please sign up, join thousands of others that get weekly insights directed to their inbox every Monday. So, and if you want to go even further on PFAS, really geek out on PFAS, here are the sources that we've used as we put the content together that you've heard today. So you can dig in further. You can see that we've done our homework here, and feel free to use this. And also, you can always contact and reach out to the EI team. I think I have a link here to our email address, so you can always ask us further questions if they don't occur to you today. And with that, let me jump right into the emerging issues questions, the Q&A portion. And I'll start with Bill. Hopefully you didn't step too far away from the mic, Bill.
I'm here.
I think this is for you. What type of impact do you think the Supreme Court's decision regarding Chevron deference will have on the future conduct and authority of the EPA?
A good question, and yeah, I would submit that it does in the near term. This kind of gets to the last few comments I made. I think in the near term, it is, those are a positive. That development is a positive for the industry. Again, layperson's interpretation. It offers to private parties a more reliable, I guess is the word that comes to mind, a more reliable pathway to challenge, say, directives from the EPA. So, or at least it offers a pathway, whereas under Chevron deference, a court might have said, hey, look, the EPA, they're the experts on these cleanup matters, tough luck. Now, in the ending of Chevron deference, the courts have, private parties will have an opportunity, I would think, to challenge some of the findings or directives of the EPA. So I would think it's in the near term a positive for the industry, and importantly, although I do believe elections have consequences, and I do think the future could be different depending on the fall election and which administration is in place and what their priorities are. I do think the ending of the Chevron deference does help in either of those scenarios level the playing field a little bit between private parties and the governmental agencies.
Makes good sense. Thank you, Bill. We do have a few more minutes here. I'm going to make sure we get our money's worth. And we have a question, just to spread it around a little bit. I'm going to pass this one to Greg Scobletti. You had mentioned that there are many hundreds of PFAS that aren't currently being addressed in either the Superfund or National Primary Drinking Water rules. Is that because there are no health concerns associated with these compounds?
Thanks, Andy. No. In fact, we often talk about PFAS like it's monolithic. It's a monolithic compound, but obviously there are hundreds of different PFAS compounds out there, some of which do not fall under the scope of the current EPA regulations, but which have surfaced in research as problematic. So the EPA actually recently ordered testing for one such compound, NMEFOSE, a type of PFAS, and they are also subsidizing or offering research grants to private universities and other research organizations to study 140 different PFAS compounds. So there are a lot out there with various stages of our understanding of their health impacts, but there may be a significantly higher number of PFAS compounds that may have some health concerns than the ones that are currently being addressed in, say, that primary drinking water regulation.
Thank you, Greg. And we're going to do a speed round here. We've got like just a few minutes left. I'm going to throw this one at Lucian, and then we'll conclude. Lucian, don't have much time, but hopefully you can tackle this one. Is PFAS litigation just a U.S. phenomenon, or are we seeing claims elsewhere?
Oh, yeah, that's a good question. Thanks, Andy. So the U.S. does continue to be the primary focus of most of the PFAS litigation that we're seeing to date, but we have started seeing quite a number of notable developments abroad, including in the United Kingdom. We've seen developments in certain European countries, as well as Australia, among others. So just a small sampling of some representative examples. You may have heard earlier this year that the Swedish Supreme Court held that high concentrations of PFAS in plaintiffs from contaminated drinking water could be considered a bodily injury, which is a very interesting development in terms of what might constitute bodily injury from PFAS exposure over there. We've also seen some significant settlements coming out of Belgium, in particular between certain chemical manufacturers and local governments related to PFAS contamination. And then lastly, there have also been some headline-grabbing settlements in Australia, most often between certain governmental entities and plaintiffs related to contamination from the use of AFFF firefighting foam. So to sum up, these are some early indicators, or maybe some early indicators of a broader trend of growing PFAS litigation outside the U.S. And just as a teaser, we in Arium are actually conducting some initial investigatory analyses to potentially expand our model review to other jurisdictions, so that we can start supporting portfolio management for exposures outside of the U.S. as the litigation potentially spreads. So we believe there's much more to come on that front for PFAS outside of the U.S. So great question. Thanks, Andy.
Thanks, Lucian. Exciting news there on that worldwide perspective that you're taking, or you hopefully will be soon taking at Arium. So more to come on that. Definitely we'll be keeping a close eye. With that, we're coming in at the close of the hour. So on behalf of Greg Scobletti, Lucian McMahon, and Bill Wilt, I just want to thank you for taking time out of your day, keeping us in your workflow. I know the past hour, it takes time to be here and learn, but we're all psyched that you're here. As a reminder, today's recording should be posted on core.veris.com within the next few business days. And until next time, be well, everyone, and enjoy the rest of your Thursday. Thank you.